Hey everybody, we're back in the Shanty. So tonight we're going to do the same sort of thing we did last time. I'm going to do a little introduction on the topic that I want to cover. That's the shortened statute of limitations that we talked about last time, and give you a little update on that. And then we're going to talk about something else. So let me start with the statute of limitations issue. You all will recall that last time we talked about the Michigan Supreme Court's decision incorporating the term sexual orientation within the term sex for purposes of the Elliott-Larsen Civil Rights Act, and that how that got me thinking about what you might want to think about with your application and with your acknowledgement of your employee handbook. Excuse me, that edit was a cough. And how I said that you might want to think about adding a shortened statute of limitations to give yourself some extra protection, because we could do that under Michigan law, both Elliott-Larsen and the Persons with Disabilities Act and some other Michigan statutes. One of you pointed out to me, and I did not know this at the time I did the Shanty, that the Michigan Supreme Court is currently considering that issue. In a case called McMillan versus City of Kalamazoo, the court has directed supplemental briefing and oral argument to address whether a previous Court of Appeals decision correctly held that limitations clauses, like the one I talked about in employment applications, are part of the binding employment contract, and some other issues that they want addressed. So that raises the question, should we be adding that statute of limitation? Now, here's my opinion on that. Other lawyers at Warner might have a different opinion, but my opinion on that is yes, you still want to think about going ahead and adding that limitations period if you haven't done so. And I say that for two reasons. Number one, because on July 21, 2022, so what, I don't know, 10 days ago, 12 days ago, a Court of Appeals panel held, in the face of this Supreme Court ordering briefing, a Court of Appeals panel still held that a 180-day period of limitations, a 6-month period of limitations, was valid in the context of what they called a supplement to an employment application. So the courts of appeals are still upholding this. The second reason why I think you should do this is, in order for the Michigan Supreme Court to overturn this, they will have to ignore several years of precedent. The Michigan Court of Appeals have been holding these things valid for quite some time, maybe back as early as 2001 in a case called Timco. So I still think it's worthwhile for you to add that limitations period in your application and handbook if you don't have it. Plus, if the Court of Appeals does overturn it, and they might, precedent doesn't mean what it used to mean, it's an easy fix. We can just take it out. So that's issue number one. I wanted to update you on that, and thank you very much for pointing that out to me, the person that did. So what did I really want to cover tonight? Well, what I wanted to cover tonight, what I wanted to talk about is something else that we're seeing a lot of come across my desk in the office, and that is conducting internal investigations. And when we should conduct an internal investigation and who should conduct an internal investigation. And I want to spend a minute doing that and talking about that right now. So there's a lot of reasons why you might conduct an investigation. The simplest is you've got productivity issues, or you've got people not doing their job, or you've got people taking extra long breaks, and you might want to look into whether or not that's actually happening. And when we have that kind of investigation, that's something that a supervisor, frontline manager, HR, anybody can do. But there are different kinds of investigations where you might want a little more horsepower, and you need to be a little more careful about who is conducting those investigations. For example, you might have an ethical issue. Let's say you've got a code of conduct, a situation that involves an allegation or a potential allegation of a breach of company policies or unethical business practices, or something that could turn into a whistleblower case. And you might have something that involves criminal issues, white collar versus corporate crime, white collar crime committed by an individual, corporate crime is crime committed by agents of the company. You might have something like that. And then you're going to not want your frontline managers to investigate. You're going to want more horsepower. And we'll talk about who in a minute. The third thing, big group of things that you might need to investigate, are discrimination and harassment issues. Those are probably the ones you were thinking about when I said investigation. And you need to investigate those because the law will punish you if you don't, with maybe potential extra liability or liability that you wouldn't have had otherwise, and will reward you if you do it well by mitigating your damages or maybe getting out of liability altogether. So when we have a discrimination issue, race, religion, sexual orientation, sex, age, something like that, or a harassment issue, primarily a sexual harassment issue, but it doesn't have to be. It can be religious harassment or ageism or something like that. That's an entirely different kind of investigation that you want to have, you want to approach in a different way than the guy who's coming back from break late or who's malingering or who's not doing their job. So the first thing you really need to do is figure out, what are we investigating here? How serious is it? All of these things are serious. I'm not saying some are and some aren't, but some have more potential liability for the company than others. It's way more likely that you'll get a big lawsuit on say a harassment issue than it is somebody getting fired for time card fraud or something like that. So once you figured out what kind of an investigation you're doing, what level of investigation you're at, you need to think about who's going to investigate. Who's going to do this? And remember, look, if we're talking about, the poor productivity time card kind of investigation, it's a frontline manager, it's a supervisor, it's your HR department, it's whatever you want to do. But when we're talking about discrimination or harassment or ethics or criminal investigation, these are very serious and they often raise legal concerns. They are not routine, and you shouldn't treat them as routine. You always want an investigator who is trained in how to do this, knows how to get the information that you want to get from people in a way that is not open to question. Somebody who's neutral. You want somebody who's well organized. You want somebody who's going to get the facts for you. Okay? So what you want to do is you want to figure out, at what level do we need now to investigate this? Is it my HR department? If so, do I have somebody who's trained to do this in my HR department? And by the way, you have to have a pair of people. You never do these alone. You want a witness, right? You want a witness in there. And what we want you to do, we want you to do this. We want you to engage your lawyer early, whether that's in-house counsel, whether that's us. Engage your lawyer, another outside counsel, but you want to use us. Engage your lawyer early, because we have to start thinking about things like the attorney-client privilege. And when is that going to apply? And what do we want to have privilege? And how do we want to try to protect it? All right? So who's going to investigate? Now, if you're big enough, you might have a department that does this. Some of you I know have departments. That's all they do. They handle ethics investigations, harassment investigations. They handle all that stuff. Most of you don't have that luxury. So think about in-house lawyer, HR, outside lawyer. We have lots of people that do these, believe it or not. Madeline Lane in our office does investigations a lot. Brian Lennon is also a criminal lawyer, does investigations a lot. Ryan Gronzik does a lot of these investigations for me and my clients. So we have a group of people that can do these for you. And think about whether or not whatever issue you're dealing with rises to the level that you want to get an outsider involved. And you might want to get an outsider involved because you want a lawyer involved, somebody who knows how to do these. But you also might want to get an outsider involved depending on the political sensitivity of the issue you're investigating, right? I mean, let's face it. Some things are more politically important internally, that you have an investigator who is going to be completely neutral than others. And that's one thing that you want to consider. So you want to make sure you select the right investigator, and there's a lot of things that go into that, right? If you don't select the right investigator, it can cause liability. There's some case law out there. I'm not going to talk about it, but it's out there that will that holds that if you pick the wrong person, it can cause you additional liability. So keep that in mind. I'm going to clue you in on that shortly. So don't worry about it. I didn't leave you hanging. The next thing you need to ask yourself is, all right, how are we going to investigate? What are we going to do? Who do we contact? What's our reporting obligation? Is it going to be prompt? What are we going to do about confidentiality and no retaliation? We have to protect and preserve records. You got to do that right away, okay? You've got to do that right away. There's some warnings you may need to give, especially if you're a lawyer when you're talking to a witness. One of them is called the Upjohn warnings. If you have a union, there's additional considerations like getting the union involved and making sure that you're doing that correctly and promptly, and a bunch of other things that you want to do. But the three basics are this. You want to find all the witnesses, you want to get the complete facts, and then you want to document the facts. All right? Now look, I can't give you the whole spiel here. Because if I gave you the whole spiel here, we'd be on here for an hour, hour and a half, and that just isn't going to work because I'll lose you. You guys will be bored out of your skulls with me in about 5 minutes. So what are we doing this for then if you can't give me the whole spiel here? Aha, you say. Here's what we're doing it for. On August 16th of this year at noon, from noon to 1, we are going to have a webinar on this exact issue. It's an hour long, and it will go into incredible detail on how to conduct this investigation. When I say we are having a webinar, not me, Warner Norcross and Judd, Ed Bardelli, who is an employment litigator and who's been on this podcast, Amanda Fielder, who has also been on this podcast and an employment litigator, and Madeline Lane, all three of whom are partners in the law firm. Madeline Lane does a lot of investigations. I just mentioned her name, and happens to be a criminal attorney, are going to conduct a webinar on exactly how to do these investigations, and they are going to get into a ton of detail. They've got some great case law examples of what kind of trouble you can get in if you don't do these right, and if you don't handle them correctly. Yeah, we've got stuff in there to scare you to death so that you'll call us. That's kind of what we do, you know. But they're going to give you everything you need to know about how to conduct one of these investigations and conduct it right. So if you want to do it yourself, you're equipped to do that. Or if you want to reach out to us or to somebody else, you know what the issues are. So if you're interested in the webinar, it's complimentary. There's no fee. You can go to the website under events and scroll down. You'll see the invitation. Hit the register button. Fill in the blanks. And away you go. And we'll see you on the 16th. I'll probably be there, although you won't be able to see me or hear me because I'll just be in the audience. And that's probably better that way. Otherwise, we'll see you next time. And I'll talk to you later. Bye.